Now, I'm not one to gossip, but I will bring you the tea. Welcome to Chronicle Speaks.
Please, I don't have any time for any gossip now. Eh? Yes.
Look at you.
This Diddy case is turning into the Ringling Brothers bad boy of entertainment circus. They say Diddy is inside of the jail and the inmates are fighting over who is gonna make up his bed, while Diddy is telling everybody, smile, daddy.
This how I smile.
But the real drama is going on outside of the jail between the prosecution and Diddy's team. However, the prosecution unleashed the beast last week when they revealed their hand, showing that they have been monitoring Diddy using 8 other inmates' phone accounts to evade his calls from being listened to. He's also been using unauthorized texting apps and making unauthorized 3-way calls to communicate messages to witnesses and people who are not on his authorized call list. Lastly, the government stated that there was a pre-planned sweep of the jail, and during that pre-planned sweep, they obtained some notes from Diddy's cell, but unfortunately for the prosecution, Diddy's team has stated those notes contained attorney-client privilege information, and the government is completely wrong. And because of that, they have called an emergency evidentiary hearing that will be held today at 3:00 p.m., and it's going to be up to Judge Subramanian to find out if the government was indeed in the wrong. And last but not least, we are going to speak about attorney Tony Busby, who in his last court filing stated that he had over 200 victims that are filing suit against Diddy. Well, now a high-profile Los Angeles-based celebrity who wishes to keep his name anonymous is suing attorney Tony Busby for trying to extort a payout in return for not identifying this individual as a sexual abuser tied to the hip-hop mogul P. Diddy. So many intricate pieces of this P. Diddy puzzle are starting to fall apart, and we are going to need Humpty Dumpty to put it all back together again. We are going to get into this story and so much more, but before we do, please be sure to subscribe to this channel and hit the bell for notifications so you don't miss out on any news regarding this case and so much more. Now let's get back into it. Now, if you believe you have heard it all, unfortunately you have not. Diddy's attorneys have recently asked that the shackles be taken off his feet so he can dance.
All in the video, all on the record. Dancing.
Diddy's attorneys wrote a letter last night requesting that the U.S. Marshals Service unshackle Diddy prior to bringing him into the courtroom, not only for the evidentiary hearing that is scheduled today at 3:00, but also for all future hearings. They believe the shackles will not only prejudice the jury, but also diminish the dignity of Diddy, as well as interfere with his ability to communicate back and forth with his counsel. Now, in my opinion, they have far bigger issues to tackle than Diddy wearing chains on his feet inside of the courtroom, especially considering Diddy is in jail, child, running it like bad boy entertainment, paying inmates to use their phone accounts, texting whomever he pleases, including witnesses, even having attorneys making 3-way phone calls for him. As Diddy says,
I'm a savage. Whatever I want, I'm going to get. Whatever I want, I have to get.
Unfortunately for Diddy, Judge Arun Subramanian did agree with his attorneys, and they decided to let the shackles go. Now, Diddy's attorneys state that there was a search and seizure in violation of Diddy's 4th, 5th, and 6th Amendment rights, and because of that, there was an emergency evidentiary hearing that is scheduled for today at 3:00. Now, the government states that this was already pre-planned prior to Diddy being arrested, and it had nothing to do with any particular inmate, including Diddy. Now, an investigator was assigned by the Bureau of Prison to participate in this week-long sweep, and he was present at the Metropolitan Detention Center during this operation. Now, this investigator spoke to not only Diddy, but to other inmates as well to see if there were any possible corruption going on. Now, during this sweep, as we said before, Diddy's cell was indeed raided. Inside of his cell was a manila folder that said legal, it was closed, and there was a notebook, and on the outside of the notebook, it was titled Things to Do. Now, the government is stating that no physical materials were seized from Diddy's cell. However, the investigator did take photos of Diddy's Things to Do notebook, and in these notes, the government is stating that they have a strong reference to be drawn from the defendant's communication with witness 2, which happens to be Kalina Harper of Dirty Money, and his personal notes is that the defendant paid witness 2 after she posted her statement, which they're stating is largely notes to self written by Diddy. Now, the government is stating with respect to the materials that they received from the Bureau of Prison that included possible privileged materials from Diddy, such as notes recovered from his cell, the prosecution team only accessed those materials after they had been reviewed by the filter team. So the filter team is responsible for reviewing and filtering sensitive or classified information, ensuring that no information gets out that would be considered attorney-client privilege. However, Diddy's attorneys are upset, stating they were never informed that any of Diddy's notes had been seized and turned over to the U.S. Attorney's Office and to the trial prosecutors, and they're now trying to use this information against Diddy, using the notes that he had in his notebook about paying Kalina Harper as reason to not let him out, because now he's witness tampering. So Diddy's attorneys have now been granted this evidentiary hearing, and we're going to have to see how this all goes down. Now, I want you to hear this snippet from attorney Mark Garagos, who once represented not only Diddy, as well as Michael Jackson and Chris Brown. Take a listen to this.
The prosecutor filed their response at 5 o'clock, and I read it at 5, and I will tell you that it was not what I expected. It basically conceded that they did invade the attorney-client privilege. So they're now hoisted between a rock and a hard place, basically arguing he shouldn't get out of on bail because he can prepare for trial and review the billion terabytes of information while in custody, at the same time saying, well, we're going to execute a search warrant on his cell, and there's an investigator there, and we're going to seize materials, and we're not going to run it through the taint team. I think they've got a lot of questions, or the judge is going to have a lot of questions tomorrow at 3 o'clock, so I would stay tuned. The prosecutors may have bitten off a little bit more than they can chew.
And of course, Mark may be a little biased because his daughter, Teeny Garagos, is working alongside Agna Philo in Diddy's defense. This just in, Diddy's attorneys have filed another letter right before the evidentiary hearing, and they're stating that the government has committed an egregious, willful, and harmful breach of attorney-client privilege and have become privy to defendant and defense counsel's trial strategy, including areas of expert testimony, witness strategy, and other confidential matters. Today, Diddy's attorneys have been provided with 19 pages of material seized from Diddy's locker at the MDC, and according to the government, these 19 pages were given to and are in the possession of the trial team, which has already started using these privileged materials to their own advantage, including giving them reason to oppose bail for Diddy. Based on the information provided, an investigator took photographs of several different items. These items include an intact page from 2 different legal pads, pages of an address book, a ripped out folded over page of a 3rd legal pad, a ripped out page of another legal pad, and a ripped out page of yet a different legal pad, as this will be described below. In short, according to Diddy's team, these notes contain confidential information like trial strategies, defense witnesses, and expert opinions. These are clearly privileged communications between Combs and his legal team, and the defense argues that the government illegally assessed these notes and used them to their own advantage, which could harm Diddy's ability to a fair trial. Diddy's attorneys claim that the government deliberately kept the notes from the defense and failed to follow proper procedures like informing the defense about the seizure and having a special taint team review the materials for privileged information. This suggests the government acted intentionally to use these privileged materials against Combs. His attorneys go on to say if the warning legal wasn't enough, the notes are obviously legal material that he discusses with his lawyer. They repeatedly refer to his lawyer by name. On the 14th page, he writes about blank, which they blacked out. He also wrote about blank. It is hard to imagine a more self-evidently privileged conversation than a trial lawyer telling a defendant about a blank and a defendant writing it down in his legal materials because it is so important. On the same page, Mr. Combs wrote about blank. This is heartland trial strategy being expressed in detail in notes of conversation between Mr. Combs and his lawyer. The fact that a government investigator, government taint team, and the entire prosecution team viewed this and still believe they can keep the notes and use them against Mr. Combs is unfathomable. They go on to say that the government's explanation of how it took these notes is riddled with self-contradiction and lacks common sense. Baby, I'm telling you, it's not looking good for the prosecution if this is at all true. Now, lastly, let's talk about attorney Tony Busby. Now, the law office of Quinn Emanuel filed a lawsuit yesterday in California against Anthony Tony Busby for extortion based on Busby's threats of publicizing false information for financial gain. In the lawsuit, Quinn Emanuel states that Busby has established a pattern of leveling baseless, fabricated, and malicious allegations at high-profile individuals and threatening to name them publicly if they fail to pay exorbitant sums of money. According to news outlets, there is a mystery high-profile John Doe that is accusing Busby of extortion and is currently suing him. This high-profile individual is apparently an associate of Diddy, but their relationship is unclear. Now, the suit accused this person of arring multiple minors, both male and female, who had been drugged at parties hosted by Sean P. Diddy Combs. Doe claimed that he received demand letters urging him to pay in order to keep his name out of these lawsuits, and these demand letters has caused him intentional emotional distress. Tony Busby responded by saying this: "I've been sued in Los Angeles in a last-ditch attempt to stop me from revealing names in public lawsuits. It won't work. The irony, the suit against me was filed by a powerful John Doe. Here is my full statement. We won't allow the powerful and their high-dollar lawyers to intimidate or silence sexual assault survivors. It has been reported that a lawsuit has been filed against my firm claiming extortion. The lawyers that filed it also immediately called TMZ in an apparent effort to silence those who allege sexual assault. Here is the deal. The case against my firm is not only without legal merit, it is laughable. Here is why. On behalf of two clients who allege sexual assault, we sent a standard demand letter to a New York lawyer that we know represents an alleged perpetrator and potential defendant. The letters were sent seeking a confidential mediation in lieu of filing a lawsuit. No amount of money was included in the demand letters. No threats were made. The demand letters sent are no different than the other routinely sent by lawyers across the country in all types of cases. It is obvious that the frivolous lawsuits filed against my firm is an aggressive attempt to intimidate or silence me and ultimately my clients. That effort is a gross miscalculation. I am a U.S. Marine. I won't be silenced or intimidated. Neither will my clients. Since our professional efforts at resolution obviously have failed, we will instead disclose the demand letters that we sent at the time we filed suit. Abuse of the legal system unfortunately runs rampant. The lawsuit filed against my firm is a prime example of that. Sunlight is the best disinfectant. I have confidence that with full public disclosure, all of this will sort itself out." Tony Busby. I said it before in this video and I'll say it again. This is becoming a straight up clown show. What I need to do is hear from you. What do you think about everything going on in the world of Diddy? What do you think about what the prosecution did? Do you think Diddy's gonna get out? Leave a comment and you know how we do. We'll talk about it down below. Talk to you guys later. Bye. As always, thanks for watching. But before you go, don't forget to hit the subscribe button, hit the like button, and hit the bell so you don't miss out on any of my new episodes.